Good morning, everyone, and welcome to the Mason Hayes & Curran webinar on trademarks, filing strategies, and case law updates. My name is Gerard Kelly. I'm a partner and I head up the IP team in Mason Hayes & Curran, and I'm joined by Eimear O'Brien, a senior associate on the team, who's going to start off by talking about some filing strategies, and then I'll deal with the second half of the talk on some case law in interesting areas around trademarks. We do want the webinar to be as interactive as possible, so there is a Q&A function that can be used by participants, and we'll deal with those questions at the end. So over to you, Eimear.
Thanks, Jerry. So I'm going to start off by looking a bit at what is the concept of a trademark and what type of elements can you trademark. Now, I know some of you would be very familiar with what a trademark is, and you might be at quite an advanced stage with your trademark filing portfolio, but others might be at the start of the branding process. You might be looking at designing the brand for your initial business or even for a new product that you're looking to bring to market. So in terms of what is a trademark is a sign which is capable of distinguishing the goods and services of one undertaking or company from those of another. And clients often come to us and ask, can you copyright my brand? Can you patent my logo? And while these separate IP rights might well apply to some of your goods and services in different ways, when we're talking about your branding and essentially what the consumer sees and what they visually use to identify the goods and services as coming from you, then we're generally talking about trademarks. And the type of elements that can be trademarked, I've set out a list of examples here. They're by no means exhaustive, but they are an example of the ones that we see most commonly. So words, designs, letters, numerals, colors, shapes, position marks, patterns, packaging, and sounds. Now, this is just a list of terms, but what does it mean in practical terms? Well, it means that we're looking at things like your flagship brand, your company name to the extent that it's consumer facing, your product name, a product shape, and the graphics or color schemes that are on your packaging or your marketing materials. And I've used Heineken here as a good example of a brand who has quite a few different trademark registrations that cover different aspects of its branding. So in the top right corner of the slide here, you'll see the word mark for Heineken. And underneath, you'll see the visual representation of the entire bottle product and the placement of all the different elements of the branding on it. To the far left, you've got the can version of the product, again, with the representation of the branding on it. And in the middle, you've got an example of a color variation and also some individual elements of the brand that they've chosen to trademark. So while we're looking at what can be trademarked, it's also really important to understand, I suppose, what can't be trademarked. And that's why I've set out in the next two slides just a list of examples of what cannot be registered as a trademark. So at the top here, marks not capable of distinguishing goods and services. And I mentioned this briefly before because this is essentially the core function of a trademark. It must be capable of distinguishing your goods and services from those of your competitors. Secondly, marks devoid of any distinctive character. And what we mean by distinctive character is that a consumer is able to identify your product or service through your brand as coming from you. Next, we have marks which have become customary in the current language or established practices of the trade. And this just means that the offices aren't happy to allow people to have a monopoly over certain aspects or words or even images that are just customary and commonly used in that trade. So an example would be the silhouette of a knife and fork for restaurant services, for example. Next, we have descriptive marks. And what we mean by a descriptive mark is a mark which has a meaning which would be immediately perceived by a consumer as describing or providing information on the type of goods and services that you're providing. So an example of a mark that has not been allowed by an office on the basis that it's descriptive would be clear Wi-Fi in the field of telecommunications and also steam glide for electric irons. And I just want to stop here for a second because the last 3 points on the slide there, marks devoid of any distinctive character, marks which have become customary in the current language, and descriptive marks. While yes, they are generally a bar to registration, there is one exception that you can rely on to overcome this objection. And that's what's called acquiring distinctiveness through use. And Jerry's going to look a little later about how this has been applied in practice. But what it essentially means is that you've been using the mark for a number of years, and while on its face it mightn't be distinctive and it might be a little bit descriptive, you've been relying on it, and over time customers have come to identify your goods and services from this mark. And if you can provide evidence of this to the office, then you might be able to overcome that objection. Now, the last point on the slide here is marks which consist of the shape arising from the goods themselves. So shape marks can of course be registered, and again Jerry's going to look at some examples of shape marks later on, but there are certain types of shapes which an office won't be happy to register. And for example, this is shapes which result from the nature of the goods themselves. So for example, a realistic representation of a banana for bananas, because of course that shape comes from the natural product itself. And also shapes that are necessary for the product to obtain a technical result. And a common example of this, and I put an image here in the slide, is the Lego block. And while we all might see the Lego block and automatically associate it with Lego, the actual shape of it itself is required in order to provide that technical result of the blocks fitting into one another. So we'll move on to the next slide. We're looking at marks contrary to public policy or the principles of morality. So an example of a mark contrary to public policy would be Bin Laden, or any mark that is seen to promote terrorism, racism, or any concept contrary to public policy. Marks contrary to the principles of morality. So an example of a mark that's been refused by the EU office is Screw You, for being contrary to the principle of morality. So marks likely to deceive the public as to the nature, quality, or geographical origin of the goods or services. So deceptive marks. And an example of this would be, for example, lacto-free for products that do contain lactose. Marks applied for in bad faith. What we essentially mean here is where the application has been made to undermine the interests of a third party, or it hasn't been made in honest commercial practices. And Jerry's going to look at some case law later on this concept of bad faith. And finally, marks identical or similar to a mark already on the register in respect of identical or similar goods. And this is basically to prevent confusion in the marketplace and to prevent any duplication across the registers. So between the last two slides, there's a list here to give you an example of the types of marks that won't be registrable. It may be the case that more than one of these will apply to a particular mark. So if we take a recent example, say a mark that might be the term COVID or contain the term COVID. So that's likely to fall foul of a few of these provisions. For example, it might not be capable of distinguishing your goods and services from those of another because it's so commonly used. Speaking of being commonly used, it is a term that is now customary in the language. And so it's very likely that a term like COVID would not now be able to be registrable. And before I move on to the next slide, I just want to briefly mention something. In the list that I've outlined here, all of them except the last point, so the marks identical or similar to goods already on the register, they're all what we call absolute grounds, except for the last one, which is a relative ground. And I'm just mentioning this now because this will become relevant later on when we look at the examination procedures in each of the offices and how they differ slightly. So to move on to the next slide then, when you have your brand ready to go, you've decided on a mark and you want to look at filing, the question that we'll be asking is, where are you selling or marketing your product or service? And if the answer to that question is the Republic of Ireland, then it's very likely that the national Irish trademark is going to be the best option for you. The appropriate office for filing a trademark in Ireland is the Intellectual Property Office of Ireland, or the IPOI. And all of these trademark types that we'll be looking at, the registration is for 10 years in all of these jurisdictions, and it is renewable indefinitely on payment of a renewal fee. Excuse me. So for the Republic of Ireland, we're looking at a national Irish registration. Now, if you want to include Northern Ireland, that will come under the remit of a UK national registration. And I'll look at a UK national registration a little bit later on. So when we're sitting down with clients and we're asking where are you selling or marketing your product and trying to decide the best jurisdiction for them to file in, we don't just ask where are you selling or marketing right now, but we ask where might you want to sell or market in the next 5 years, or where is your business plan going to lead you, what jurisdictions might be in your future plans. Because 5 years is a magic number in trademark filing, so to speak. And that's because after 5 years of registration, your trademark may become open to challenge for non-use. And that means to the extent that you haven't used your trademark for any of the specific goods and services that you have specifically outlined in the specification, then a third party can come along and potentially have your mark partially or fully revoked, depending on the extent of the non-use. But the flip side of this is that you have this 5-year buffer period at the start where you don't necessarily need to use your mark straight away. And we can use this 5-year period to maybe look at what other jurisdictions you might like to file in, and it might be more cost effective for you to file in those jurisdictions at the outset. I wanted to also mention here priority applications, because this is something that we get a lot of questions on. And it's quite a confusing name because a priority application isn't actually an express application or a fast-tracked application, as the name might suggest. Because of course, the length of time that it takes for your application to be examined and to reach registration is actually irrelevant for the purposes of when your protection will start from. So if you are granted registration for a trademark, your protection will always start from the filing date. So whether it takes the office 6 months or 12 months to examine your mark and to grant you registration, you're still at the end of the day going to have your protection from the filing date. So what exactly is a priority application then? Well, a priority application is an application that's filed 6 months or within 6 months from the date of an initial application. It's identical in every respect, and it can benefit from the earlier filing date of the first application. So for example, if we were to file an Irish national application today, and within the next 6 months, we thought that we might like to actually file in another jurisdiction. And provided that the mark is exactly the same in every respect, so same owner, same representation, same goods and services specified, then we'll be able to file what's known as a priority application if the jurisdiction that we'd like to file in is party to the Paris Convention. Now, the Paris Convention has 177 parties, so it's the likelihood is that the jurisdiction that you will be looking at is going to be covered by the Paris Convention, but we can confirm that, of course, for you at the time. So if these criteria are satisfied, then you'll be able to rely on your initial application of today's date, and you'll be able to use this filing date. So this can be a good strategy, not just for when you decide within 6 months that you want to file in another jurisdiction, but if perhaps you're not sure that the initial application is going to be successful, you're worried that the office might object to it for one or more reasons. So we might run a test application in a jurisdiction that has a pretty short examination period. That means that the office is going to come back to you with an answer within 6 months. And then, provided that's successful, you can decide whether you want to invest more money in filing outside that jurisdiction and into other jurisdictions. So if we're looking at a market that's expanding outside of Ireland, we're looking at the European Union. And this is by far the most common trademark application that we file on behalf of our clients. The European Union trademark application is great because it's one application that results in a unitary trademark right across all 28 member states. Now, of course, soon to be 27, but I'll discuss that more in the next slide. So the European Union application is filed European Union Intellectual Property Office, or the EUIPO for short. And as I said, the main benefit of filing this application is that you get protection in all of the member states of the European Union. But there is another reason why strategically we sometimes look at filing in the European Union as opposed to a national Irish application. And that comes down to the difference in the examination procedures between both offices. And you'll remember that I mentioned earlier about the distinction between absolute and relative grounds, and how the relative ground, which are basically the the relative grounds for refusal are that where there is a mark on the register which is identical or similar to your mark for identical or similar goods and services likely to cause confusion, then the mark will be refused. So the Irish office, when you submit your National Irish application, will run a search of the Irish register and also of the EU register, which of course applies in Ireland, and they'll detect any marks which they consider to be identical or similar for identical or similar goods and services. And if they find any, they will object to your mark on that basis. And you won't be able to proceed to registration unless you can overcome these objections. Now, the EU office is slightly different because they still run the search of the register, of the EU register, and they detect whether there might be identical or similar marks on the register. But instead of just objecting to your application outright, what they actually do is they write to all the owners of these prior marks, and they just let them know that a similar application, being your application, has been filed. And they give them details of what they might have to do if they want to object or oppose your application. So sometimes the risk of objection can be slightly lower with the EU because it is entirely dependent on this third party owner of a prior mark having the motivation to file an objection or an opposition against your application. So now I mentioned the UK national mark, and that's going to become more and more relevant now after the 1st of January next year. And we received quite a few queries from clients about how best to go about filing for protection in the UK now, but also what happens in EUTM that you currently hold that applies in the UK right now after Brexit. And the answer to this I've summarised here in this slide. So what's going to happen is, if you have a registered EUTM at the moment, after the 1st of January 2021, the UK IPO, the UK Intellectual Property Office, is going to create a comparable national registration for you. And what that means is it will be a UK national registration. It will be absolutely identical to the registration that you currently hold with EU, and it will be granted the exact same filing date. So for all intents and purposes, the protection within the UK will remain the same. Now, the UK office isn't going to go to the administrative task of issuing national UK certificates for all of these marks, so you won't get a new certificate in the post, but you will be able to access details of your comparable registration on the UK office website after it is created. So now, if you have an existing application before the EU IPO that's not likely to reach registration before the 1st of January next year, what will happen is that you'll be given 9 months from the 1st of January. So essentially, you'll be given until the 30th of September 2021 in order to let the UK IPO know that you would like to apply for a comparable registration. And what that will mean is that a comparable registration will be created exactly the same as in the previous point. It will have the same filing date as the EUTM application, and it will have all the same details. But you will have to pay the examination fee to the UK National Office in order for that comparable registration to be created. And of course, if you're looking at filing an EUTM application after the 1st of January next year, it will have no effect in the UK, and you won't have the option of creating a comparable filing within 9 months. You will have to consider filing a UK national application separately. So if we move then outside of the European Union to jurisdictions further afield, you can, of course, file a national trademark application in any jurisdiction internationally. And the ones that we look at most for clients would be the US, Canada, New Zealand, Australia. And we have contacts in all of these jurisdictions and more that we work with regularly to file trademarks on behalf of our clients. So we can be a centralized contact and manage the worldwide portfolio through us as a single point of contact. But sometimes it can be more cost effective to consider an international registration. Now, an international registration is not like an EU registration. It's not a unitary right. What it actually is, in effect, is a bundle of national rights. And you'll file your international application and you'll designate which countries you would like included in it. And each additional country will require an additional fee to be paid. So the international application is made through WIPO, which is the World Intellectual Property Organization. And it can be made and designating any countries who are party to the Madrid system. Now, the Madrid system currently has 123 countries party to it. So again, it's very likely that the country that you're looking to designate is going to be part of it. If it's not, then you can look at a national registration in those countries. But by and large, we find that the vast majority of countries clients are looking at will be covered by the Madrid system. And to give you an example of some recent additions, in 2019, Canada joined, as well as Brazil, Samoa, and Malaysia. So we now have 123 in total, and many more may join. So the one thing to note when it comes to filing an international application is that it's not a fresh application that you file with WIPO, so to speak. What you need is a basic application or registration in an office of origin, is the terminology used. So you file either a national trademark, for example, in Ireland, or you file an EU trademark, and you use that application to ground your international application. So it is identical in nature, and then you simply just designate the additional countries that you want it to be assigned to. Now, the important point to note in this is that if within 5 years, and again, we're back to the magic 5-year number, if within 5 years of the international registration, your basic application falls, and by fall, I mean it's successfully opposed by a third party, or it's cancelled or invalidated, then the entire international registration will fall. So what we generally look at here from a strategic point of view is to make sure that your basic application or registration is in a country that is likely to be successful and not likely to be opposed. Or we'll also wait until your application is registered before using it to ground an international application, because then obviously you've gone through the opposition period and you have an idea if there's any third parties out there that might be against the mark. And the other thing to note when it comes to the international application is that you can subsequently designate additional countries after the fact. So even though you filed your initial application, a few years down the line, if there is other countries that you would like to join, you can simply pay the additional fee and you can subsequently designate them. Now, they won't be granted the very initial filing date of the international registration, but it can be a more cost-effective way of adding jurisdictions rather than going down the national filing route. So that's just a synopsis of the type of things that can be registered as a mark and what you need to watch out for, the things that can't be registered, and also just an idea of the types of jurisdictions to look at and what might be the most appropriate jurisdiction for filing your brand. So I'll pass you over now to Gerard, who's going to look at some case law updates.
Thanks, Eimear. Just in relation to the case law, I've put it into a number of categories. I'm going to look a little bit around colour marks, shape marks, and store layouts, which is more of a recent phenomenon. And then obviously there is the issue of bad faith that Eimear touched upon a little earlier. So just starting with colours, you'll see the first case here is a very recent decision of the General Court at an EU level, and that involved Glaxo with their purple colour inhaler for asthma products. And effectively, they had introduced that colour. They were the first in the market to do it. No one else had sort of purple there, but it was held to be invalid, and predominantly because, as a public policy, courts and offices want to ensure that no one entity gets a monopoly in a colour. So that's why there has been, and we'll see in some of the other cases I'm going to deal with, a requirement that there needs to be a lot of precision in respect of the application by way of a particular Pantone or international colour code like RAL, etc. And here it didn't have that. It just looked for the shade purple and therefore had a number of shades possible. And that was obviously something that was allergic, I suppose, to the office and the court. So it wasn't inherently distinctive to have purple on the inhaler product. Now, that doesn't necessarily mean, as Eimear referred to, as fatal, because you can try and demonstrate an acquired distinctiveness of the colour or any other mark through use. In other words, does the public or consumers involved perceive it to be a badge of origin in respect of your company, and in this case, Glaxo? So some evidence was put forward to the office, and indeed the court looked at it, both by way of consumer survey evidence and by way of evidence from medical practitioners around the EU. The difficulty with that evidence, because it wasn't held to be sufficient, was that it didn't refer, for example, to a specific shade of purple, again, very generic in the way it described purple. So that was a fundamental flaw in the evidence that was put forward. And it was also considered by the court that colours are used quite a lot in that industry, and therefore they should be sort of free to use. That's not to say there aren't other industries or services where colours are also used as a designation. You'll see in courier delivery services, Post has the colour green, for example, registered as a trademark, but indeed you'll see DHL with their yellow, UPS with their brown. These are all colours which they can demonstrate through use are very much associated with them for the particular goods and services. If we look at the next case, this is a combination, and Red Bull, the very famous energy drink, we've probably even seen the cars driving around the city at times, they have obviously got delivery of their can registered as a trademark, like the Heineken bottle or can that Eimear had spoken about. Here, however, they tried to expand that monopoly, and what they wanted to do was to get the colours blue and silver, and then they did describe it by way of an international colour code, RAL in this case, but they wanted to have it in any way 50-50. So it could have been vertical, as you see on the slide there. It could have been horizontal. It could have been diagonal. It could have been with polka dots or whatever. As long as the 50-50 split was there, that's what they were trying to protect. Now, that was held to be imprecise and not acceptable, because obviously there is a public interest in keeping colours free, but also there has to be clarity and precision in what is being sought. Another example, which I don't have on the slide, is the colour purple for the Cadbury Dairy Milk chocolate bar. That also fell foul of registration being declared invalid, simply because they wanted to protect the colour purple predominantly on the packet of a chocolate bar. Again, what does predominantly mean? There's too many combinations involved, and therefore it couldn't be accepted. So on the next slide, we're going to talk about shapes now. Keeping the theme of chocolate bars, we have the Kit Kat four-finger bar, which I think it's accepted that everyone associates that with Kit Kat. But what you look at here is whether it's actually acting as a badge of origin. And that's one thing which Kit Kat, Nestle being the proprietor, had to defend themselves against, because Cadbury took an invalidity action against that four-finger registration. The bar, as it set out, was held not to be inherently distinctive, particularly because other indicia and livery and get-up would be taken into account by consumers, such as the red wrapper that you see, or indeed you can see half of it there on the screen, the Kit Kat embossed on the chocolate itself. The brand name on the bar would be more of an indicator of origin, as opposed to necessarily the four-finger chocolate bar. Having said that, again, it's not inherently distinctive. So there was an attempt made to show that it acquired distinctiveness through use. But again, the evidence here fell down. There wasn't enough of a sample around the EU. That's not necessarily fatal. You do have to show it's been used and acquired distinctiveness throughout the EU, because as Eimear had mentioned, an EU trademark has a unitary character. So it has to be of the quality of a trademark throughout the EU, but you could have certain regions in your survey. But here it was held that the evidence was not sufficient, and predominantly because the evidence didn't demonstrate that the four-fingered chocolate bar itself was acting as that badge of origin with consumers. There were other indicia or trademarks acting, such as I said, the chocolate embossment of Kit Kat. So moving on to the next slide. Again, on the issue of shapes, here is the Rubik's Cube, and we're looking at this from a slightly different angle. It's not necessarily, is it inherently distinctive, but to look at the exception that Eimear had mentioned around shapes that give a technical function and whether they should be a bar to registration as a trademark. And again, it's very much a public policy issue where the legislature and the courts don't want a particular company to have a monopoly in something which brings about a technical function, in the same way colors. Here we have the famous Rubik's Cube, invented in the 70s, winning Toys of the Year in the 80s. It's been around for quite some time. Obviously, the rotating capability is something which potentially could have patent protection, Having said that, if it did get patent protection when it was new and qualified otherwise, it would only last for 20 years. So at this stage would be expired. So that's why there's an attractiveness in going for trademark protection, because as Eimear had mentioned, it lasts for 10 years and can be renewed indefinitely. As long as it's being used, it's not really going to be subject to challenge, etc. So here, what the court looked at was what are the essential characteristics of this trademark as it's been depicted and as it's been attempted to be registered. And it was held that it's the overall cube shape and indeed the black lines that are used in the depiction, not the differences in colors on each of the faces. That was held not to be an essential characteristic. So taking those essential characteristics, the court then examined, do those essential characteristics give a technical function? And here, the black lines are clearly there to facilitate the rotation of the cube, to play the game effectively and to bring the colors together as you do. And again, the overall cube shape is again in that shape to facilitate that rotation, etc., and the game in the way it is. So therefore, this trademark fell foul and was held to be invalid. So if we move on to the next slide, we'll see an example of an English case. And this is a very recent case from this year. And this involved the Baby Bell wax seal over cheese products that you may be familiar with. And what was sought as a trademark here was effectively this depiction, which was described as obviously a product, which was red and in the dimensions that you see set out on that depiction. Now, again, what was probably fatal to a large degree here was that there was not a particular shade or hue, as the cases this particular case was talking about, of the red. And what the judge here felt was needed was that there was a particular shade of red which would be associated with the proprietor of this cheese product. It wasn't in the application, and therefore this was held to be lacking in clarity and precision and couldn't be registered as a particular trademark. So moving on then, another example of shapes which fell foul recently of an invalidity action. And this is the Ferrari 250 GTO, which is the most expensive car in the world, as I understand it. If you have 52 million pounds, you might be able to buy one. They were obviously done in a limited run in the 60s, haven't been produced since. And much later, obviously, Ferrari sought to protect the shape, as you see depicted there, as a trademark for both new cars and indeed toy cars. And it was held invalid because it wasn't being used within a 5-year period for new cars by Ferrari. Indeed, the last one was produced in 1964, as I understand it. So therefore, it was clearly going to get invalidated or revoked for non-use. For toy cars, it was being used and therefore could remain on the register. So it's important where we're trying to protect the shape here. And what has happened now is that there is no trademark to protect that particular shape. That's not to say that somebody could produce it necessarily with, obviously, as you see, the yellow Ferrari badge with the stallion on it, because that would be a separate trademark in its own right. But as the shape is going, it's no longer a trademark on the register because it hasn't been used. So if we move on. Finally, in relation to shapes, we're looking at the shape of this Oreo cookie. And here we had a Spanish company who have their packaging on the left. Oreo was protected through the registration on the right. And again, it is the words Oreo, quite prominent and dominant indeed, and obviously the depiction of the cookie biscuit itself. And a number of concepts came up in this particular case. So it was being defended by the Spanish company on the basis that when you look at the Oreo trademark on the right, the biscuit element isn't in fact dominant at all. It's more the Oreo branding name that should be considered versus their depiction on the left. That was not agreed. Given the product concerned, it was held that consumers perceive both the product depiction and indeed the branding name, and therefore both could equally be dominant and both are equally taken into account. So there is, to a degree, a level of similarity here. It was also argued by the Spanish company that in the opposition proceedings, the biscuit, the Oreo cookie biscuit shape, wasn't actually distinctive at all and should actually be ignored. But it was held as a matter of, I suppose, practice and procedure and law that you can't object to an earlier registered mark not being distinctive in an opposition, you would have to somehow in a court case or issue fresh or different invalidity proceedings. In other words, you're attacking the registration rather than simply defending an opposition proceeding. So that didn't succeed either. And because the products here were pretty much exactly the same, given the reputation of Oreos, etc., there was held to be a likelihood of confusion in this particular case. So just moving on then to store layouts. I simply raise this because it is something which is more prevalent now as an issue. Obviously, for the next 6 weeks, we'll see less of them. But Apple managed to get a registration quite recently for its quite distinctive store layout. It was probably one of the first stores that used a sort of a table concept rather than necessarily shelving, where the store attendants would walk around and talk to you and you would interact with the product. So they had managed from the Court of Justice to succeed in getting a registration for this. If we move on in the slides, we'll see a cosmetic company, KIKO, had filed for their store layout in the way you see it there. It was refused at the EU IPO, but it wasn't appealed. It was let sit, and it obviously then expired as an application pre-Apple. If it had been obviously pursued post-Apple, the decision in the Court of Justice, it obviously perhaps would have got registered. Now, you would ask, when you look at the next slide, would somebody actually bother trying to not just copy a product, but would they actually try and copy a store layout? And the answer is surprisingly yes. And there's an Italian Supreme Court decision of this year. You'll see on the slide on the right, KIKO has their depiction of how their store looks. Pretty similar, obviously, to what they were trying to register. Obviously, there was a different concept being put forward there, but this is how it would look in real life. And on the left, there was Icon, which is a cosmetics company who was arguably setting up their store in a very similar way. So the trademark wasn't there, so it couldn't be relied upon. Otherwise, the case could be taken to say that there is a likelihood of confusion in seeing the store on the left versus the stores on the right. Now, that wasn't, funnily enough, the end of the matter, because we've seen the courts in more recent years, the Court of Justice in particular, look at the issue of copyright and expand that as an IP right beyond what we originally thought it might cover. So it was held by the Italian Supreme Court that, notwithstanding the lack of the trademark, because it noted obviously the application that didn't follow through, there's the potential that the store layout was protected by copyright as an artistic work as such, as long as there's enough intellectual creation and creativity in the way it's set out. So there was actually a potential redress in this particular case. So moving on then finally to bad faith, and Eimear had mentioned this as a ground. Here we have a very, very recent decision, and this involves Banksy, who's an infamous street artist who's anonymous, so nobody knows who he or she is. And for that reason, we have the flower bomber depiction there. But for that reason, because of the anonymity, relying on copyright isn't possible, because you'd have to come forward as the artist so that you could claim ownership, and indeed that it's within the term of protection, because copyright lasts for the life of the artist plus 70 years. So if you're anonymous, you're not going to be able to rely on copyright. That is a problem, because that then allows people to copy it. And what was attempted here was that Banksy had a number of associates who tried to register them as trademarks. And here they were challenged on the basis of bad faith, because these are artistic works. They are not being used in the sense of a badge of origin to depict the products of one company over another. And it wasn't even being used in this particular case prior to the challenge. So for that reason, the court was looking at what is bad faith. Well, it's considered some sort of dishonest intent. When you look at it objectively, is the applicant acting within the honest commercial and business practices expected of somebody within the sort of sector? And here it was held that this registration or application, for example, went against that and therefore couldn't be registered as a trademark. On the next slide, on my final example, we'll see Sky took an action against SkyKIK, a software company. And again, obviously, the difference between the marks is evident based on the slide. Obviously, Sky is part of SkyKIK, but there's obviously the kicker at the end, I suppose. And we have the situation where here, the counterclaim that was made was that Sky had registered Sky, even though it's a media and entertainment company. SkyKIK claimed that they were more in sort of business tools, software type scenario. They weren't in the same sphere as such. But Sky had registered computer software under Class 9 per se, didn't really distinguish it in any particular way. So there was a counterclaim made in those proceedings for trademark infringement and passing off by Sky that it was registered in bad faith on a number of grounds, but predominantly around the fact that the specification of goods and services that Sky had was too broad, and that there was no real intention to use the application that they had. Now, it was beyond just computer software. It also included things like whips and bleaches and things like that. So effectively, Sky was being registered for absolutely everything. But the focus here was on the sort of telecommunications and the software. So it was held by the Court of Justice that it is not bad faith to simply register a trademark for a broad description of goods and services. That was interesting because the Court of Justice actually went against the Advocate General's opinion. The Advocate General felt that as a matter of public policy, if a company was registering a trademark too broadly, or certainly without the real intent to use it to impact third parties, as a public policy shouldn't be allowed. But the Court of Justice didn't agree with that and held that you cannot invalidate or partially invalidate a mark for that reason. So then, concluding, we have some points there on the next slide. And maybe, Eimear, you might start with a few of the take-home points from your part of the talk.
Yeah, of course. So the first one here is it's never too early to consider trademark protection for your brand. And this is, of course, to obtain the earliest possible filing date. But it also ties into the point that I made earlier about this 5-year buffer. It might be more cost effective for you to consider multiple jurisdictions at the outset if the intention is to expand your brand into those jurisdictions in the next few years. Second one is consider what type of trademark best suits your branding. So with the Heineken example earlier, you'll see an example of the various different types of trademarks that you might be able to file for one general branding concept, like word marks or your logo, different elements of your branding. For example, if you have a downloadable app, you might have a favicon symbol that you might want to register separately to the word mark in your overall branding. So there's definitely different elements to consider there. And the third one here is consider filing in multiple jurisdictions in line with any plans for future expansion. And that again ties into this 5-year window that you have. And also just to ensure that you get an early or filing date, or as early as possible a filing date in any jurisdictions that you might want to move into. Because of course, when it comes to opposing a mark or opposing anybody else's use of a particular mark that you think is conflicting with yours in a jurisdiction, it may come down to who has the earlier mark and the earliest filing date. So it's just to bear in mind that you can consider multiple jurisdictions at the very early stages in your brand development.
Just maybe to take away a couple of points from the case law that I was talking about. Obviously, precision in filing is important, not necessarily in the description of the goods and services as we've seen from the Sky case, but more in how we're describing the trademark itself. If we're going for colors, we need to be able to refer to specific international codes so that there really is clarity on what's being looked for, not necessarily an infinite number of combinations which are felt to lack precision and for public policy reasons won't necessarily be allowed. But also, if it is something like a color which inherently may not be distinctive, even though you've been using it, you need to look at acquired distinctiveness through use. You need to make sure that the evidence that you're putting forward to both the courts or the office are in fact sufficient to sort of meet that need, that when you're asking the questions, you're asking the right question. Looking at that mark, who do you associate that with, etc. So finally, then, we just have some questions, and I think I've seen them come through. So maybe, Eimear, I think there's one here that you could answer because I think it's to do with the Heineken example you had. Does the registration of the red star as a trademark mean the red star cannot be used by anyone else?
Yeah, so the short answer is no. The red star for Heineken and indeed a lot of the Heineken trademarks, they're registered in class 32 for beers. So if a mark is being opposed or if a court is considering this question in the context of infringement proceedings, what they'll look at is the similarity between the marks, but also the similarity between goods and services. So if the goods and services are similar to the registration, then the answer is no, you shouldn't use that mark. But if you're in a field that's entirely separate to where Heineken and their branding lie, for example, in construction or pharmaceutical products, then there's likely won't be a difficulty with using a red star in branding.
Thanks. I see a question coming around. Typically, what's the total cost of registering a trademark in the EU? So I suppose I know that depends on the number of classes concerned and to what extent there's obviously oppositions and objections. But if you just want to give a sort of maybe a rough idea.
Yeah, so a rough idea, I suppose, for for a national Irish trademark application would be about maybe €850. Now, it will depend on how many classes you want to file in. So additional classes will typically add about €70 to each application. And for an EU application, we're generally talking about €1,500. Again, additional classes generally around €100, €150 per class, depending on how many you have. So that's just a ballpark.
Great, thanks. And then there's another question: is how long does it take to reach registration? Again, that's probably going to depend on the jurisdiction concerned, but maybe you just look at that one.
Yeah, absolutely. So what we typically say for Ireland and the EU would be about to expect about 6 to 9 months. 6 would be relatively fast. That's because when you file your application, the office is going to take some time to examine it. We generally say, 4 to 6 weeks. It could be 6 to 8 weeks, depending on what kind of backlog they have. Once the office is happy with the specification, now, of course, they might write back to you and ask you to change a few bits and pieces. They generally give a month or two to respond, so these things can push this time frame out. But once the office is satisfied, they will publish your mark. There'll be a 3-month opposition period to allow third parties to file an opposition. And if no oppositions are filed, then within a few weeks, it will proceed to registration. So, if there's no issues, we're talking 6 months, but generally to allow for a bit of a question back and forth with the office, we'd say about 9 months. It could be longer, but it's important, again, as I mentioned earlier, to remember that the length of time doesn't affect when your protection starts from. Your trademark protection will always start from the date of filing if it's ultimately registered.
Yeah, I see a question here about what other IP rights can apply to the shape of the Ferrari car if a trademark isn't available. Well, that's an interesting one, because one thing I haven't mentioned, obviously, is the issue of design rights. Now, that's something which is available potentially to the shape, the ornamental appearance of a shape. Wouldn't have been necessarily a feature of the law in the 60s when this car was particularly created. But if you were to create the shape of a new car now, you probably would be looking at design rights, as long as they're a new individual character, which is the test. Be it either the unregistered community design rights, we don't have unregistered national rights here, that would last for up to a maximum of 25 years. The other potential is copyright. That's a lot less certain at the moment, because, as I say, there seems to be a shift in allowing the potential to protect functional type products. There's a Brompton Bike case from the UK, for example, where the Court of Justice has said it's potentially possible to protect those. So it remains to be seen. But there are, let's say, for new cars created now, a number of options beyond trademarks to potentially protect the shape of a car. I see the question come in about a registered company name and domain name. Will that give trademark protection? Well, the answer is no, on the basis that neither of those, be it a company registered name, a business name, a domain name, actually give any rights to that name, certainly to enforce against others. It's obviously part of a use that you're making, and over time, You might build up goodwill for passing off action and have unregistered trademark rights. That's more around the goodwill from your trading as opposed to necessarily something attached to a domain name or company name. But if you want to have a right that's enforceable against third parties, a trademark is what you have to sort of go. And questions come in about, if your brand consists of a name, is it necessary to register both as a word and as a logo? Well, for that, we quite often file both. The cost involved in applications is relatively modest in the scheme of things, and there's no harm in filing both. Obviously, they both achieve different aims in the sense that the word mark will protect it being used in sort of any way, if it's slightly different font, etc. The logo will focus more on the embellishment and the sort of the get up of that logo. And so there is obviously a benefit in perhaps, and what we would normally advise to do is to register both in those instances. Eimear, there's another question here about, we're selling in Ireland and the UK only. What is the best jurisdiction for us to file in?
Yeah, so at the moment, because of the proximity, I suppose, to Brexit and the fact that EU TM applications won't be applying after the 1st of January, it's very unlikely now that any EU applications filed would apply or would get to registration before the 1st of January, excuse me. So right now, if you're talking about filing in Ireland and the UK, you would definitely be looking at a UK national trademark application. And then it just depends between an Irish national or the EU application, which would best suit the circumstances of the trademark.
Okay, and there seems to be a final question here about, can you outline the major classifications of goods and services? Well, there are 45 of them. Everything under the sun effectively can be covered under one class or another. There are 35 for products, goods. There are 10 for services. So 5, for example, would be medicinal products. 9 would be computer software. 16 would be books. 25 would be clothing. 32 would be beer. 35 would be retail services. It sort of goes on and on. You just have to find the best match for what you're doing, and that is sort of an art in itself, because the office, when it gets the application, will try to ensure that there's consistency in how particular goods and services are being described, and it may be that when you file an application, you get a query back from the office, which can delay things slightly in dealing with, as to describing it in a particular way, or indeed if the good or service has been put in the wrong class, that will need to be either moved to an appropriate class or indeed an additional class fee paid. So I think that's it for the Q&A. Thank you very much for joining us today. There is a short survey that will go around. We'd appreciate the feedback, and it'll obviously give you an opportunity to indicate any future talks you might like to have us do. And thanks very much.
Thank you.